day in the hallway, you're singing, "Oh, happy day."
One word prayer. Justice, where are you?
Okay, then here we are. Justice Serve TV. Michael Bryant here.
Linda Kenney Bott here. I like that opening, that countdown, so much better than the other countdown. Thanks, Joan.
I remember when we first started doing this, whenever that was, and we know nothing now, but we knew less than nothing then. And people said that intro's too long, and so
right.
we chopped it up to whatever it was, 7 seconds, and then I'm thinking, why are we using that canned 30-second countdown? And one of your friends, relatives said, get rid of that.
Yeah, my sister, actually. My sister was the one who said, I watch all these podcasts.
It's the same 30 seconds, so might as well use what we got. Anyway, so we did, and there we are. So
and now you know
Monday,
about us, if you didn't know about us.
Yes, if you did. Yes, right. Now we know you're an author and a celebrated trial attorney, et cetera, et cetera. So today, Monday, busy day, a lot of stuff going on. We're going to cover a few different things, some more in depth and some just kind of updates on stuff we have been covering. I suggest, since I'll be heading that direction in not all that many hours, we start with Boon, which has been very interesting.
Where's justice is going to Florida.
And efficient. The thing's really been unfolding very efficiently. This judge, Michael Kranick, as I told you before, I talked to some local attorneys. I think he's a straight shooter, very, very efficient. And that I'm seeing that. I do think sometimes he feels like it's going overboard to confirm certain things. As I've said, prosecution, do you recognize our jury? Defense, do you recognize? Yeah, they look like the same people to me, Judge. I think it's interesting. And then he'll identify the defendant and what she's wearing. He'll put that on the record each morning. So anyway, every courtroom is different, and this one is a pretty ship shape. So
Afton said he was an administrative judge for a long time. That would explain his attention to detail. Although, wrongful convictions are based on misidentification, one of the leading causes. So I'm not sure identifying the jurors that come in is like.
Yeah, it's sort of intimidating, isn't it? It's like, I'd rather judge. You'd rather not, focus on that kind of specific identification. And remember, only 6 people in the box, but 8 alternates. And we're going to find out, every court does it differently. I believe they identify alternates up front in Florida. Some places they don't. They pull names out of a barrel. I think Ohio does that. So you got 8 people that are sort of connected, but maybe not, a little bit disconnected. And they went long today. In fact, I think they might just be done because they ran the defendant's both interviews today, but the longer one that was done on 2/25. The day after the initial interview, the day after the body was found, and all of that was done. And so that took a while, and they had to get the okay from the jury because they had been told early on, 5 o'clock, you're done, you're out of here. And obviously they had to go, had overtime today. I don't think there's any overtime pay. But yeah, so they went overtime so they could see that whole thing.
Yeah, and they had the medical examiner on today. Some pretty.
Yeah, I'm glad you mentioned that.
So that was, a matter of fact, something that's kind of connecting both of our cases that we're going to, or some of our cases we're going to talk about, including the Richard Allen cases, is the gruesomeness of the day today on both trials. So, Michael, yes, the medical examiner, she was on. Yeah,
she was on, and she did the actual autopsy, not just somebody who reviewed the records, which happens quite often, especially in this is a pretty big county.
That's right.
Orange County. So I want to play a little bit of her testimony, and then have I've got some demonstrative exhibits here to talk about some of the.
You have a Louisville Slugger.
That this one is. This is actually a Louisville Slugger, and this is to go a little bit
same weight.
further.
Is that the same weight?
It's pretty close. They're within a few ounces. Most Louisville Sluggers, if they're legit. You may know this, maybe not. You're not. I know you're not a huge baseball fan. This was used by Jenry, Jenrry Mejia. Now, he used to be a New York Met. Now, for those who know who he was, they might be thinking, what's he doing with a bat? This guy was a relief pitcher. Well, not too many years ago, pitchers in the National League actually batted. So this is a game-issued actual bat. It's got his name on it there somewhere. There it is.
Yeah.
And it has his number on the end. They're all everybody gets these. That's just the way That's just the way they do it.
Yeah, but you weren't on the team, so how did you have it?
People bought. I bought it for my son.
Okay.
Anytime you can go online and find game used whatever, game used jock straps. I mean anything you can find, bases, balls, bats. So I have this, which I think
I really don't like that first one.
it's going to be close to the bat that was used in this case, and then I also have this, which is exactly the same size, including 8 7/8 depth. Okay, so we'll get to that in a minute. But before we do, let me see if I can call up here. Let me test my technical skills, which are questions.
Well, wait a second. We should tell our viewers that you are actually going to be in the courtroom tomorrow.
Yeah, and I've heard rumors that Ms. Boon is going to testify tomorrow. So,
Well, that's good timing. For where is
good.
Justice? Justice had these tickets a while ago, and you must have had some inside information.
all I did was push our trip a week because the hurricane pushed everything else a week. So we'll see if it all works out. Let me see if I can find what I'm looking for here. Stand by, please.
Okay.
Let's see if I can find her here. Just talk amongst yourselves. I've got it here somewhere. Let's start with, where did she go? Her name was an interesting name. I only heard it used once, and I'm not sure I can even pronounce it. It had a witch on the end of it, W-I-C-H. So hold on just a second here. I'm supposed to be able to just run this little button right here and do a little something like this, and then do something like this. There we go. Okay, again, this is the ME. Did the autopsy of George Torres Jr.
Bankowitz.
So this is his right arm near the elbow. And right here, you can see this kind of darker area. So this looks similar to an abrasion, but it's actually, it's what's called drying artifact. And again, this is one of the reasons that I think that he was in that suitcase for a little bit longer. Most likely that was a pressure point where part of that suitcase was resting on his elbow in that area. And then after death, that tissue dries out, and that's the discoloration that you're seeing there.
Look how skinny he is. I mean, that's just so thin. Ugh.
Well, I think it was what, 5'2", 103 pounds.
Yeah. And you can see no muscle mass in his arm. That was kind of a mistake. You're kind of seeing his lower jaw.
So here you can see a little bit better. I don't know if you can get a feeling for this, but this area is what we call edema or swelling. So this whole area is edema. It's a little bit discolored, so ecchymosis. And then again, really at the corner of the eye here, you can see that darker discoloration. And so those are injuries from blunt force trauma.
Stage 4 from the composite.
So this is the left shoulder and arm. So again, you can see this kind of red to purple area. So this is all ecchymosis, and then a couple of linear abrasions or scratches.
I would have asked where were the scratches from if you know, and when did they happen, but they didn't even ask.
Stage 5 from the composite.
This is the same area, just a little bit closer up, so you can see this whole area of ecchymosis. It's a little bit variegated, differential in color, but again, that's all blunt force trauma.
And what part of the body is this we're looking at?
This is the left shoulder.
So we'll see in this next one, the actual shoulder, that area.
Stage 6 from the composite.
That's the same area, but in this picture we have a scale or the ruler.
And why do we use scales or rulers?
That's just to give an idea of how big the area is or how large the injury is.
So there you have some of the injuries, and why they're so important in this particular discussion is that she's talking about what may have caused them, right? You know, and that's where the bat comes in. And the question became, and on further examination and on cross, she was asked, were those injuries something that could have been sustained with a baseball bat or a fall down the stairs? Now, remember, it gets back to the two folks who testified on Friday, the neighbors who share the adjoining wall, that both heard this really jarring thud or thunk or crash at or about 11:15 on the night in question, which would have been the Sunday night, 23rd of February in 2020. that was all. It kind of came and went. Well, now, your mind's racing. Okay, what could have caused that? Did she toss him down the stairs in the suitcase? Did his body just fall down the stairs after being whacked? So if you're using this, and I'm going to try, I don't know how well this is going to work, but I'm giving it a try. If you've got, this baseball bat and somebody's whacking you with it, this would be the area they showed those bruises, upper body right here in the upper left. Obviously that's going to make some serious impression. Whether this was used, there was also a wound up here to the crown of the head, actually more like the arch over the eyebrow. There was some edema in that area, some swelling. So I think the question the jury's going to have to figure out is, was that, baseball bat to body contact, or was that, as we recall, when he was put into the suitcase?
Right. In a fetal position. He was in a fetal position.
That was her best guess. Nobody knows.
Right. Dr. Sarah Zadowich, I think it is.
Yes. I got the which part right. That's all I could remember. When we saw the body cam footage, we saw George Torres laid out on his back on the floor. I'm not sure they meant to include all of that, but you could clearly see it in one of the body cam videos. So we know he wasn't in the suitcase when the ME came along. In fact, I don't think he was in there when anybody first responding was there. I think she took him out of the suitcase.
Right.
So you have the suitcase. Let's assume, and this is ironic, I think. Remember, part of their deal was the zipper part was torn off the tab.
Right.
That's what happened to this suitcase. I don't know how long ago. And I didn't replace it with a paper clip, which is one of I think what they suggest she replaced it with. This is like a key ring because it's a little easier for me to get a hold on. But that's not unusual for that piece to come loose. In this particular case, so it's open a couple of inches. Let me see if I can simulate that. It's open only a couple of inches around the top. And his fingers, two of his fingers were sticking out. Okay.
Right.
Now remember, I don't think it's disputed anymore that he got into the suitcase himself and then tried to zip himself in as best he could, perhaps. And then he had his two fingers sticking out right here. So I envision that there was this kind of,
right.
Get your fingers in there.
Yeah, his fingers in there on the top. I mean, he's in a fetal position, so it's easier to access his head. It's easier to access his shoulder if you're hitting hard enough.
If he is laying down, if his head is like this, here's his head.
But remember, he's going to be moving his head. He's going to be moving his head around trying to get out. He's not staying stationary then. He's trying.
No, I'm just talking about general orientation, because he ain't flipping over in this suitcase. Once he is in a fetal position, there's no rolling around.
No, but he can squirm. But he could squirm. Right.
But he ain't flipping. Okay,
right.
So if he's laying in there, head here, shoulder up here, shoulder down here, right? So he's sideways. That's the only way you're going to fit into that kind of width, right? And then his two fingers would be up there, and maybe she's bashing him. Well, maybe she's also hitting the suitcase,
Right.
When he is wiggling around or moving somehow. That's going to make a less impactful injury to his body, but still going to show up as blunt force trauma.
And maybe that's what the neighbors heard, because recall the two cell phone videos of him pleading, "Sarah, let me out," are surround that 11:15 time where the neighbors hear that big bang. So it's hard for him to think that he was getting out, for 1 minute, coming back in the suitcase, right?
I mean, anything could have happened. We'll never know because she was the only one there, and it's whether you believe her or not. That's, this thing could have been sitting up above the, the top of the stairs, whacked and sent tumbling down the stairs.
Right.
We just don't know. But I do think it's interesting that all of those blunt force traumatic injuries have a number of possible explanations.
Right. But whatever it is, I mean, she wouldn't let him out, and he suffocated to death.
Yes, and that's important too. That
she decided was positional asphyxia, which is what you normally see when cops do takedowns of people, and people are on top. Cops are on top of the suspect, and they die because they say they can't breathe, a la George Floyd.
So, and that is important that it was clarified that all these injuries, whatever they may have been, did not contribute to the cause of death. But they're so important in determining her mindset and whether she was doing something intentional, or at least striking him intentionally. Not sure what the cause was intended, but she has said in her interview, we've heard before, but today we hear the whole thing. This was not intentional. This was not intentional. I get the impression that in her mind, if I just make it clear it was not intentional, I get off the hook. I think she really believes that.
No, I think she believes that too. I think she's convinced herself. I mean, she's not actually in reality. And this goes back to my whole theory that, this is a case that should be brought up in terms of discussing alcoholism, because he goes in the suitcase. He's drunk, right? I think that he had by the time you do the autopsy, he's got over the legal driving limit still in him, right? And he was alive for how long before he died? A long time, hours upon hours.
11 hours is the best guess, but nobody knows for
sure. So you're at least going down 1.1. He's found, and by the time they test him, it's 1.3. So that makes him maybe a 2.4 at the time. Pretty plastered. She's plastered because she's apparently an alcoholic. I've got the 2 magnums that are in the garbage. One of them had been partaken partially. So yeah, I mean, this in her mind, her brain cells may be to the point that she thinks that she is innocent. And of course, everyone can see, in our opinion, that it may be not.
There's some level of guilt. We're still trying to figure that out. And I do want to talk about the bottles, because I think they've gone way overboard in.
Do you have?
But I think Afton has a great question.
But do you have, I saw you the suitcase.
I don't have any wine bottles.
Well, that's what I wanted to know, because then I want to know if you drank them.
No. To me, that size wine bottle is just a shade better than a cardboard box full of wine. So I don't have any of those laying around. Afton has a great question, because the defense did a good job, as best they could do under the circumstances, of pointing out that he had a 75% blockage in one of his arteries, and that could lead to, I think they call it the Widowmaker type
It was in the
problem.
LAD. Yeah, it was in the LAD. Yeah.
So they gave a hypothetical about what if they find him on the couch dead? How does that impact?
But people are walking around with 75% blockages, and they don't necessarily die.
I'm just pointing out that the defense made some nice efforts to at least raise that issue and plant the seed with the jury, because that's the job. And I think it was reasonable. I think the ME did a great job of saying, well, yeah, that's true, but there's no other objective findings that would support that as the cause of death. But I think it's very smart to bring it up.
Yep, absolutely. What else did you see today? Because you're going to be there in person tomorrow afternoon.
I know. I'm going to have to fight for a seat. I'm guessing. Did you hear what happened today with the woman and the blurt out?
I did. Go ahead.
It was just I'm still not sure if it was just somebody who showed up, if it was a friend of Sarah Boon, if it was just a local goofball. I don't know. But at some point in the trial, she said, and I think it was the point where they were about to take a break. She said to the deputy or the bailiff who was bringing Sarah Boon in, "You ought to. Did you say you should be fired?" I think is what she said, or something like that. Right. You should be fired.
Is this the Sarah Boon trial? I think
yes, that was the first thing she said.
First thing she said.
Yeah,
which is bodes well for you getting a seat tomorrow, Michael. If anybody off the street,
there might be an opening. Yeah. Well, I got my official credential. I'm pretty sure she does not. And I don't know, I'm just guessing. So yeah, I mean, that's classic, high profile trial. You never know who's going to show up. Normally they don't get inside. Normally they're just outside, making noise. But yeah, I thought that was
okay. Joe Schmo makes a great point. If he was laying on the couch, I doubt he would have died prematurely from positional asphyxia with environmental suffocation. Yeah, probably not. If he were just laying on the couch with a TV clicker. My husband, who was a forensic pathologist, Dr. Michael Baden, says no one ever died from a TV having a TV clicker in their hand falling off the couch. What they usually die from, if they're really healthy, what they think they're healthy, is when they're running out jogging, they have a heart attack. So you're exactly right.
Yeah, I gave it a shot. I'm helping the defense at least. I'm giving them credit for at least coming up with something.
Right. Something. And make their client happy, right?
Well, yeah, and it seems to be very important. With
and she's very happy. The judge asks every day, "Are you happy?" And she said, "Yeah."
another very dangerous question to be asking. Especially of this woman. I mean, what are the odds that at some point she's going to say, "No, they're screwing this whole thing up"? I mean, I will be shocked if that does not happen. I mean, it could happen. There were a couple other things I was looking at today that I thought were very interesting. Only got to 4 witnesses today, but again, we had the interview that took forever. Both of the interviews and the ME took quite a while as well. Let's see. This is more procedural than anything, because I'm always kind of a student of what goes on in a given courtroom. And we always talk about objections and speaking objections versus non-speaking objections. If you say objection, irrelevant, that's the end of it. unless the court allows you to elaborate, which then becomes a speaking objection. And this judge is, not surprisingly, a no speaking objections judge, which leads to more sidebars. And at a certain point, that becomes annoying for the jury. I haven't seen it yet. It hasn't been overused. And I'll be interested to see if the judge does something differently if it becomes overused. Because I think I object. The other side says, we have sidebar, Your Honor. That starts to get annoying to the judge as well. And
yeah, but he's the one who causes it by having a no speaking objection, which of course he can't have a no.
Yeah, I'm all for no speaking objections. I'm all for it. But it requires the attorneys to be a little smarter and the judge to be quicker. He has to be quicker. He has to figure out what their objection, the details of the objection, and make a decision. But he could ultimately just start ruling against the person who says, I want a sidebar, because he doesn't want to have all these interruptions. He's very attentive to the jury. There's no doubt.
You know what?
About
They need to be trained in federal court, because in federal court, you better know those federal rules. And when you object, you better put why you're objecting per the federal rule, and the judge will then rule. Okay, if you don't have a federal rule in there, you might as well sit down and not make your objection. There's not going to be any speaking objections in federal court.
Yep. Well, this guy, who knows? He could be on the federal bench someday. He's definitely officious enough to do that. So, anything else in the Boon trial today that you found of interest?
No, I think that was it. It was the positional asphyxia, which everyone should be aware of, because we followed the George Floyd case. We followed all the cases where people say they can't breathe. And that's basically the same thing. I can't breathe because he was, in that suitcase, his air was running out, he was compressed. But interesting thing though, but then why was he being compressed? Was he being compressed because the way he was, we didn't see him in the suitcase because he's found stretched out. And I don't think did she opine on that? Because he'd had to be compressed some way, that his abdomen here, was compressed in, so he couldn't take those breaths. And if you all right now, all people watching, put your hands on, kind of press in. If you can't breathe, or you can't have that abdominal stretch, you can't breathe. Yeah.
And I think just being in the fetal position, that's going to be an issue. Just put yourself in the fetal position right now without a suitcase surrounding you. There was I want to mention the.
Well, I was in that fetal position for a little under 6 months at one point in my life, but
you were
a while ago. Yeah.
Oh, when you were
when I was born,
before you were born,
before I was born, right?
Yeah, you were premature, right?
Yeah, I was born at 2 pounds 1 ounces.
Oh my gosh. Well, look what happened.
Those were the days. I now wouldn't fit in that suitcase.
What was it? Oh, the Publix and the liquor. Okay. I'm not sure they needed to go to all the effort to establish, here are the bottles, here's the surveillance video at the store, here are the receipts. Is there any doubt in anybody's mind? Is anybody disputing that they had 2 bottles of wine, one half empty when they started it, or half full, and then the other one that they added to that mix on the day of the incident? I just don't think it warranted all the time they spent.
No, I agree with you. I mean, and there wasn't much cross-examination, right? I mean, on it, because
no, it was really a custodian just to let them show the video, and there it is.
And that's him. There he's buying the wine.
It could have been stipulated to. It was that, to me, that was a bit of a time waster. So, I understand they want to be complete about it, but establish the wine was there, they drank it, and then move on. I think we heard the text today from the cell phone expert that we knew were coming. The texts about playing hide and seek, and how she thought that I think let me get the exact quote here. Is where she talked about getting rid of him. I think that's how she phrased it. Let's see.
Yeah, the text with the brother, right?
Yeah, I'll get rid of him. Yeah, and this is to the family member. Then I'll be better. Ugh.
That's not a good. That's we try to teach when we teach up at Harvard trial advocacy that there's no such thing as a bad fact. That's a pretty bad fact.
That's pretty bad. That that was the day before.
Yeah, timing is not on her side.
Yeah, and yet even if you watch that video, I don't know. I'm still torn about the level of intent. Was she pissed off at him for some reason that's still unclear? No doubt about it. Right. But did she intend for him to die? That I don't know.
Yeah, that's what the jury's going to be wrestling with.
Yeah, exactly. So tomorrow, they're going to have some stuff in the morning before she testifies. I have to assume, unless they're doing some out of order juggling, that the state's going to rest tomorrow, because there's no reason for her to take the stand otherwise. And again, we've got people flying in from here and flying in from there. I would not be surprised to hear that the state has other out-of-state witnesses that are now, unavailable, and that they're going to basically let the defense out of order put on, in this case, if it happens, the defendant. I don't like that.
I don't like that either, but it also may be the state's going to rest early and use some of the witnesses for rebuttal too, based on the battered spouse syndrome.
True.
defense.
True.
So,
And those may be the experts that are parachuting in.
like you're parachuting in.
Parachuting in, yeah.
Yes, you're right. I'm right. We have an umbilical cord. I realize that. I didn't say that I was breathing in there. I just said I was in that position.
Yes.
Joe, thank you.
What's that? Oh, yeah. I mean, there's no doubt about,
But she's going to, what? Is she going to be, here's the thing. Is she going to be hated so much when she testifies, or people are going to say, this woman is cray cray. Okay. And that's going to mitigate any intent she could have. That's going to be an interesting dynamic that you will see tomorrow.
Yeah, I'm looking forward to it. I think the way she animates in court, and she's very active. She's note taking. She's talking to her attorneys. I expect her to be just like that on the stand. And if she's going to be testifying in the narrative, it's going to be very interesting. And I think if that happens, it's to protect the attorneys, because they don't want to put themselves in a position where they're suborning some sort of perjury.
Right. We just saw that in the was it the Trellis case? The same issue, right? The Trellis, was it that he was sentenced recently for killing the reporter Jeff Germain. And he testified in the narrative, even though he had attorneys. And the reason why you do that is you file some kind of papers with the court. You can't say my client is going to lie. But everyone kind of knows why you're filing papers, that you don't want to do a direct examination. And the judge lets the defendant get on the stand and testify in the narrative form. And there are no questions. They just go along with the story. So that's an interesting dynamic there. The jury will not know if she testifies in the narrative, why she's testifying in the narrative.
But what they'll have is a very fresh recollection of her interview compared to her testimony. And if she strays in any way, if she over explains in any way, it's going to stand out.
Yep. Oh yeah. This is good. This is going to be one for the books in terms of seeing her. And, we have to remember, too, the family of the decedent are there, right? This is it's a horrible case to think that your brother, for instance, suffocated over an 11-hour period in that position in the suitcase. It's a horrible, horrible case.
Yep. And tomorrow, let's see if they do that. Again, we won't know until they decide whether there's some out of order issues or not, because they predicted this case to be 2 to 3 weeks. Well, we're on day 2. So I got a disconnect there somewhere. I'm just starting to think things are going to happen out of order to accommodate some of these other witnesses. So
yeah. So we'll see. But
we'll see. Let me check one more of my many notepads here, and you can tell these are official, because see, look at that. It says, does that say reporter's notepad on it? Somewhere?
It does, but what happened? Where's the mine's over on my table?
I did order some more that have our logo on them, just in case.
Yeah, they're just to serve logo, right?
But see, the thing is, the one that you have there, and I have one here somewhere. It's too big. I like the kind that fit right in your coat pocket. That's the key.
I don't have a coat pocket.
That's the key. And these kids these days, because I've been watching, and thanks to 35 out of Orlando, I can't remember the call sign. It's Fox 35. They've done a great job. This guy, Garrett, something or other, is like in a little control box, and they have a reporter in the courtroom. So she's doing all the stuff on her phone because she's not 100 like I am. But I like the notepads. Okay. Yeah.
But actually, Michael, because I know you've been prepping for this for weeks to go down there.
Yeah, well, I don't know about weeks, but we've been covering this forever. I mean, it's been 4 years since it first unfolded.
Tell us. I said trellis. Tell us.
Oh, tell us.
Speaking of my gardening, tell us, Robert. Tell us, right?
Yep. I already complained about that. What else do I got in here?
Yeah. What do you think the prosecution is going to do in cross-examining her?
It depends on her narrative, because sometimes the best cross is hands in pocket. I mean, you've got probably 4 or 5 contradictions that you could nail her on, in terms of her changing story about accident, got in a fight, spouse. We know that's coming up. The spousal abuse issue, that's got to come up through her narrative testimony to allow the defense to elaborate on that and bring in the experts that they want to bring in. So that's happening. once that comes out, I don't know if you're the prosecution on cross, how deeply do you want to get into that? How much more air do you want to give to that?
Well, I don't know. I mean, FN says that she predicts the prosecution will show her true colors when the prosecution pushes her. I tend to agree with that because, even when she gave the interviews with the police, they really didn't push her. And that's why we're in this, kind of like, second degree, which I agree with. I don't think there was any indication that she, this was like, pre-planned, right? I think they were so drunk that once it's in there, but we also know that intent can be formed just like that. And when she says, for all the things you've done to me, not only does that give her a defense, but it also gives the ability to the prosecutor to say, well, there you had the intent at that point. Boom, you made it. So, it should have been a first degree murder. So it's kind of interesting if they push her and she kind of like cracks under that being pushed, because I don't think she's going to like it.
No, that'll be very interesting too, because I think the 8 former attorneys who they can attest to her combative nature. And that was when they were friendly on the same side. So I can imagine when the prosecution, who ain't going to be so friendly, starts pressing her, she could just pop off. Who knows?
And let me tell you, as a former prosecutor, you live for the day that the defendant gets on the stand, because that doesn't happen few and far between. As I always like to say, the quickest way to the prison cell is through being on this witness stand testifying in your own defense.
Well, tomorrow, I guess we'll see. That's the theory, and I should be, it's a long walk, but I should be there in time for that. So,
okay. All right. So where are we going next? I know we got a lot. There was so much going on today that I had trouble getting my own work done. I was trying to do my own. I'm a practicing lawyer. I have cases, and I had all these things on. I felt like a UN translator, because I had all these things on in the background. I had this. I had the YSL case on. I had the Texas Roberson hearing going on. There was just so much happening, and the Sarah Boon thing, which I know you had in the forefront. I was trying to cover the rest of the back of the cases, but there was just so much happening today. It was beyond belief.
Well, let's pick up the stray threads in YSL, because we know there was a hearing today, as folks will recall from last week, and we talked to Doug Weinstein, of course, about this. He makes a motion for mistrial based on a witness, a retired detective, inspector, investigator, whatever they call them, Mr. Dennis, who offered up, when showing a picture of Mr. Kendrick, that's Mr. Weinstein's client, standing on a car, not all that incriminating, but the detective and investigator offered that, oh yeah, that was taken right after he got out of prison. Not appropriate. Good chance the investigator, now retired, knew that, said it anyway. Was it intentional? Was it just a slip of the tongue? We'll probably never know, but I'd put a few bucks on intentional, because these people are, they're so embroiled in this whole case that they seem to be willing to do anything to upset the apple cart. So Doug comes along. He makes the motion for mistrial. It's denied.
Doug Weinstein.
It's denied. So they craft a remedy of sorts, a sanction. Judge Whitaker decides that, okay, investigator Dennis, you're done, not testifying anymore. And anything you have testified to lay a foundation for in the form of evidence, that's out too. Now, that led to an objection by Mr. Steele, who is Jeffrey Williams' attorney, that, hey, I didn't get a chance to cross this guy. So that was up in the air, an issue. And the state said they filed a motion basically to reconsider that ruling and allow some of that evidence to come in, despite the narrowly missed mistrial from Doug Weinstein on behalf of Yak Gotti and the complaints by Mr. Steele. So today they basically had a hearing on that very specific issue. And
the judge denied her changing her prior ruling. And the reason why, but it was interesting because she didn't say, well, he did it intentionally, but she says, I could see a scenario where Dennis, the investigator, actually said that because he was pissed off that the defense was questioning his qualifications and his credentialing. And therefore, that's why he did it, not to influence the jury in some way, but it was retaliation, retribution to the defense attorneys. So she kind of like created her own fact there, but she denied the ability for Dennis's testimony to come back in. And the reason why the Steele, you may ask why Mr. Steele was able to make a motion to say, hey, let the whole thing go out, and not Doug Weinstein, is Doug Weinstein represents Mr. Diamante, right? Diamante Kendrick, right?
Yep.
All right, who was known as Yak Gotti, and we've had him on. Some of you have listened to his with us, right? And then Mr. Steele has a Sixth Amendment right to assert on behalf of his client, which is the right to counsel and the right to confront witnesses on the stand. And that's the right he asserted to say it's got to be thrown all out. And that's why the judge threw all the testimony out of Dennis. And that's probably why she wasn't going to reconsider it, really, when it come right down to it.
Yeah, it happened in stages. With the mistrial motion, she prohibited any further Dennis testimony. With the Steele objection based on Sixth Amendment, she threw out everything prior to and including his direct testimony. So that's gone. That is not coming back. But we have a collateral issue that relates to Fulton County, because we're all over Fulton County.
But can we go to
you got more?
YSL? Yeah, I have one. I just want to mention something, because the state had brought up with Dennis. They brought up another investigator, Underwood, for lyrics, and I have to mention this because
the lyrics.
This pisses me off to no end that we're back on lyrics for like 2 days. And I'm just going to show you. I don't know if you have seen, this is screenshots, right, of what was going on in that courtroom. And what they were showing, I'm just the screenshot because I know you were so busy. We couldn't get those moved in. Right. They were showing lyrics. I'm sorry. That was Law and Crime, where we used to work for. Right. But it was season 3, It was Young Thug's album, came out like a number of years ago. And they were using the lyrics to say that because he said, he's after somebody had been killed, that he is no longer, that means YSL. He's, there was Robin, he was jacking, and now he's just rocking. To say that was an admission that he was involved in Donovan Thomas's killing, with the lyrics from this album that they had all over the screen. So some of you watched it, right? All over the screens with Investigator. So that was going on at the time too, that they were re-arguing this Dennis motion. I just want to point it out that we haven't moved very far, because we're back to the lyrics to try to convict Young
Again,
Thug.
I wasn't watching all that much today. Was Ms. Love back in the courtroom?
No, she wasn't.
Oh.
She was supposed to. The prosecution the DA wanted to put off, and we'll talk about this, wanted to put off the argument on the reconsideration motion. Why? Because Ms. Love was the only one apparently who could argue it. Well, the judge made them go forward.
And she wasn't even there, though.
She wasn't there. She wasn't there. Yeah, you're right. So that's exactly right. So again, you just feel like no matter the attorneys, when Steele goes down to argue, he doesn't even make the motion for mistrial, because he says, well, I'm not going to make the motion. I'm just going to put it in for the record if we have to make an appellate record, because we all know that no mistrial is coming on anything. He'll probably convict. The prosecution can probably commit a homicide in that courtroom, and there ain't going to be no mistrial. You know,
it'll be close call, though. Very close call.
Very close call, right?
Yeah. So
exactly.
I wondered if things had bogged down a little bit because she was back in court. Because when she was gone most of last week, things were zipping along pretty well.
Yeah, they're still kind of zipping. They were zipping through Underwood, who's got everything relates to the lyrics. I mean, it's just unbelievable.
That's ridiculous. And I think Judge Whitaker has made a mistake. I know she came in with a tough position to make some different decisions, but she's basically deferred to anything that Glanville said, the former judge in the case who was recused. And that was a huge early decision he made.
Oh yes. And it was really interesting because one of the attorneys mentioned, Underwood was led by the prosecutor and mentioned country songs. And they just said, oh, I love this. Speaking about country songs, right on cue, Rainette, shouldn't Taylor Swift be investigated for no body, no crime? And they said, yeah, we would look at, we look to see if there's a crime. And then, that may take us to the lyrics. If this were a country singer, we would do that too, just like we would do rap. Because at one point, Underwood, I believe, said something to the effect of this is his life. This is his life that we're talking about. Steele again makes that motion, right? Not for mistrial, but for preservation, that was basically bad character evidence. So the judge decided she's going to give a charge again, saying you can't consider that. That was bad character evidence. One investigator, Underwood, just said that. But we're just going to give a charge to the jury charge not to consider it, and we're going to go forward.
I don't like it. I think it's a horrible decision, and this is the bad reason to want a conviction, but I'd love to see it analyzed on appeal because I don't think it would stand up. I think it is totally irrelevant unless you can draw such a tight connection to the lyrics that they support corroborative other evidence of whatever the elements of that crime might be, and not the lyrics. It's a stretch. It's a big stretch, and
Yeah.
I don't think it's going to
So
stand
that-
up if there
so
is.
that was, but the way that this is all being argued, and the way we still have to give another, that they were led by the prosecutor in Fulton County. Okay, Michael, in this case that we both agree is like ridiculous with the lyrics, brings us to what you wanted to get to before, a collateral issue in Fulton County.
Yeah, we talked to Ashley Merchant. I guess it was last week, right? Last week,
That's
week
2
before?
weeks ago. About 2 weeks
Yeah,
ago.
and we knew this was just bubbling up at the time. She made a open records request, which most people know as a FOIA request, Freedom of Information Act. Depends on the jurisdiction; they've got different names. Basically, it's what anybody, any citizen, can ask of a government agency. Please provide documents relating to blah 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 blah. She was asking for documents from the DA's office. That's the one run by Fonnie Willis. That related to funding of the attorneys, specifically, of course, Nathan Wade, the former, boyfriend of Fonnie Willis, and perhaps current boyfriend, who was apparently, by all comparisons, way overpaid with potentially taxpayer money that was misused, misappropriated, used against the law to pay this guy upwards of $1 million. So when we talked to her last time, this hearing was unfolding. She had to bring a civil lawsuit. She and her husband, John, both with the Merchant Law Firm, had to bring this civil lawsuit to enforce the Freedom of Information Act, or the Open Records Act, in Fulton County. So the defendants are Fonnie Willis, her office, Fulton County as a whole. And today, they finally had the arguments to convince the judge all the evidence is in. Of course, the defense, which is, in this case, oddly enough, the DA's office, is the defendant. They have to make the argument that no, they didn't even reach the level of the threshold that we need a directed verdict, just like we see in a lot of criminal cases, but the parties are flip-flopped. And that was denied. But before we get into the ultimate decision, I think it's important to remind people of, and this guy's name came up, all day, every day. It was Mr. Bond, Dexter Q. Bond Jr. If you did not see his testimony last time, let me see if I can find, this is just a little bit of it, because I think it's important in the context of the decision, and also for those who didn't get to see him before, you might, get some sort of impression what this guy was like. And of course, I'm looking for it. I'm going to find it. I'm still looking for it. Do you have any impressions on this guy, LKB? As you recall,
do I have
his
impressions on
testimony?
him? Well, he was at the heart, and you'll see why, of the arguments today when the judge was asking questions, and the judge really wasn't having it from the representatives of the attorneys for, as they say, Madam Fonnie Willis's office. They call it Madam Fonnie Willis's. As a matter of fact, Dexter Q. Bond, I think he was trying out for the new position of James Bond that's going to be recast. It's casting now, I believe, for the next James Bond movie.
Is it really? I didn't know that.
Yeah, because the previous guy is no longer going to go, and so they're talking about having somebody else. And I think he was dressed to the hilt, and he does have the last name, doesn't he?
He already has the last name. Are they going to have? Is it going to be an African American? Is that what they're going to do?
I don't know. I have no idea. Let's talk about
let's,
whether.
Let's see what. For those who don't remember, Mr. Bond.
Who actually had access to that at the time, those are the people that would have to pull that.
So I think that you and I can agree that open records do that records exist at the time that open records were received. We made a lot of mention here that the first critical mention open records request came in January 8th, 2024. I think you and I can agree that on January 8th, 2024, we did not have critical mention. Based on the renewals that you showed me, we did not have an existing contract. So my position is neither myself or anyone with a login. The login is irrelevant. You could not get it because at the time your open records were received in January 2024, both of them, we did not have critical mention.
The law that we agreed earlier that you have to follow says that all records created or received in the performance of duty and paid for by public funds are deemed to be public property and shall constitute a record of public acts. Would you agree that reports paid for by public funds would be a record of public acts and public property?
I cannot answer that based on the framing of your question. I'm afraid it's misleading. Can I respond? My response is critical mention is something that is a database. Maybe we can educate on critical mention. Critical mention is a system
Please educate.
that you can, app, as you say, and that you can go in to get stuff, right? We use it for investigative purposes if there is for various different reasons. Because HR is under me, I use it for morale. If one of my employees do something great and someone reports to that, I want to be able to let my team know, hey, this is what we're doing in the DA's office. That's how it is being used. Now, what I need you to understand is once that system is gone, that contract is gone, I cannot maintain, preserve. The system is gone.
He's rapping.
I hear you as it relates to your assertion, as it relates to the retention act, but I need you to understand that this app is somewhat, it's not a file that I will have in my office that I will have to maintain with the retention act. Am I clear on that?
Whew, are you clear? Is he clear? Is he clear? And the judge, the judge, what a jerk. The judge even said it's clear from his testimony that he didn't like Ms. Merchant, and it wasn't just that he was avoiding her request for documents, but he actually was aggressively anti-Ashley Merchant. I mean, right. And you could just, this guy's in charge of this department. They get requests all day, every day from the public. And these people are confused. We pay your salary, dude. You know, not me. I don't live in Fulton County. But they do. You're not the boss. You're the employee. And to have that kind of attitude, and I'm glad it wasn't lost on the judge. And she mentioned it many times throughout her analysis and the decision. And the decision was, first we have to mention, there's a Supreme Court case in Georgia that has some impact on the Open Records Act and who needs to comply.
Right. Gonzalez versus Miller. It's coming down tomorrow. We understand.
It's possible that they could make a decision saying that an entity like the DA's office of a given county, in this case, Fulton County, Fonnie Willis, has no obligation to respond to an open records request. That would be surprising, to say the least. But the judge had to leave open that possibility. And so she ruled with that kind of a caveat. And she ruled what?
Well, she did rule that they had violated the Open Public, the FOIA, we call it, Freedom of Information Act, Sunshine Law, but not in the entirety, And she did rule that she was going to give some attorney's fees and at $300 an hour, but probably not going to give sanctions because she did feel that the merchant law firm had used this proceeding to possibly get some publicity for their clients in the criminal action. So she wasn't going to really entertain sanctions. She didn't think it rose to that level. But that's basically it. She said, yeah, you're going to have to comply. And one of the reasons, too, Michael, that she said that Mr. Bond had a rule called the Ashley Merchant Rule, where only the 13 requests that came in, and it's only 13, right? That he felt that they would be, no, you're not giving the documents, and you're going to have to convince me some reason why I have to give you the documents, as opposed to the way it should be, that there's a presumption that you give over the documents unless there is some reason you don't give over the documents. So, and it only applied to Ashley Merchant. Maybe
special. Yeah. And their position was, hey, if we don't understand your request, whether they're lying about that or not, if we don't understand your request, that's too bad. That's your problem. That's not our problem. We don't have to reach out to you and say, Ashley Merchant, what did you really mean by this? The judge said, yeah, you do. That's what you do. That's what the government does. If you can't understand the request, you reach out, you ask for clarification. The onus is not on the person requesting. And that's also much more important when it's the public. You know, here we have sophisticated attorneys looking for documents. If Joe Blow is looking for documents, I'm looking for my law jerk license plate denial documents. You know, they need to help you. They're not there to hide. And that's why I think you said in a note to me earlier today, nobody trusts the government.
Right. No one trusts the government.
And that's
exactly
why.
Right. Right.
So their two arguments were
thousands upon thousands of dollars to just get documents that they have to supposed to keep for you.
Yes, that's our stuff.
Right, and they were like, she was just, we wanted to know who she was working with to get these documents. The judge said that's none of your business if she's working with another entity.
Mm-hmm. And it doesn't matter what she's going to use them for, because they tried to make it sound like this is all political, the Trump trial, and of course I keep wanting to say Natalie Merchant.
I know.
music.
Ashley
Now, Ashley Merchant representing a co-defendant in the Trump case. So they were trying to lump that together. She's just using this to bootstrap into that case. It doesn't matter what she wants the documents for. We know what she wants them for. It's to show the impropriety of the Fonnie Willis office in spending money on Nathan Wade. That's what it's about. But you don't have to worry about that. You either have the documents responsive or you don't. Then their other argument was the system's all just wild. It's a mess. Some of the stuff is in IT and some of it is in Fulton County.
Right.
Well, that's also not good. Yeah,
Right.
we're all a mess. So sorry.
We're
we can't find
incompetent. We're
anything.
incompetent, so we can't give them to you. We're basically incompetent.
We have no idea, and so
have
we're
no
doing
idea
our
what
best,
to-
and it's not working.
Right,
So,
and the reverence to Fonnie Willis was just, well, they're just doing this because in their pleadings they had Clay sued Madam Fonnie Willis, and that's why they're doing it. That's what they wanted to do. Well, the judge told them to go sue everybody.
And the judge said, in kind of about throwing a bone to Fulton County folks that she can't say there wasn't some element of that impacts that case, but that's very different than saying that's the sole motivation for it. So.
Yeah, and then like the other thing that drives people crazy, you go to get a FOIA request. This one asked all the people that are employed by the DA's office and their date of hire. And well, they don't have it in that format. They don't have a list. And the judge said, I can't make you make a list like that. But we know that, of course, they have a date of hire somewhere and they have all the employees somewhere. So just give two lists, right?
At the very least, and I know they wanted attorneys, because what they're trying to do is compare salaries, Nathan Wade's money, where did that come from? And here's what people normally make, and here's what he made. They certainly have a list of all the attorneys.
Right.
That's at the very least they have that.
Yeah. And anybody else is employed, right?
Nope, can't help you. Sorry.
Can't help you. And that's what drives people crazy, that they can't from their government, and you have to litigate everything wherever you are to try to get sunshine laws, So the system is really, and that's why, again, I'm going to make people hate government, okay? And that's what's going on here.
Yeah, but I'm all fired up now, so I'm going to continue my efforts with the whole law jerk license plate in Connecticut. I just don't get it, and it's just frustrating.
No joke. Okay, we do have another case. We hope to have a guest witness, but
we have Bob Motta is he
Still
and
in trial.
Allie are down at the Delphi case.
But we can talk a little bit about it. Hopefully, he's going to be on. He's supposed to be on once he got out of the courtroom. And the Richard Allen case was going on, and apparently it was a very trying day because the pictures, the photographs are shown in court of the two young women's bodies, okay? And for the first time, you're really learning that their throats had been slit. There was blood all over. There was some trees and branches covering their body. What that means, I think Bob Motta had, on Defense Diaries, had tweeted about it. I should say X'd about it, had posted about it, as to, what that means. Was it placed there purposely or just to cover the remains? And so it really was a very, very difficult day in the courtroom when you see two young children, and their children, remember that, who are brutally, and I will say, slaughtered about that, slaughtered in that way. So that what was going on this morning, and then I think it was continuing this afternoon.
Yeah, tough case just because people want to find, justice for these girls, 13 and 14 at the time. That makes it hard for any defendant. But now you have a guy who's allegedly confessed 60 plus times and maybe was at the scene on or about the day or within the time frame within which they think this happened. So it doesn't look good for him. I think it's gonna hinge on these confessions, these alleged confessions. One suggesting he says he shot one or both of them, and of course they weren't shot.
Right.
So a lot of false sounding confessions. Maybe he's got some mental issues, suggesting that in
high profile cases, Michael, you know this. I'm going to go back to the Lindbergh case in the 1930s in New Jersey, which is where.
Oh, yeah, I remember that.
Right?
I was there for that.
Everybody and their mother was confessing. In high profile cases, people confess. Remember the John Benet Ramsey, there was somebody who confessed that he's from Pilot. People confess in high profile cases. And if they have mental disease, they confess more and more and more. And usually, the police look at confessions and they say, well, does the confession match the scene of the crime? And when they don't, they say, well, that we don't have the right person. But here, the confession didn't match the scene of the crime, but they said they had the right person. So we're going to have to see. There's a lot of problems in this case. I think Bob had alluded to them in terms of time of death and who sees what and where. So there's a lot of issues going on here.
Yeah, I guess the cops, I mean, it sounds like that confirmation bias that we hear about all the time. And, they have this very solid timeline that they're very married to, but don't officially have a time of death, which makes it very difficult to have a timeline that means anything. And then I think the most interesting thing to happen so far is the revelation that one of the girls had some strands of hair in her hand,
Right.
that were apparently not the defendants.
Right, and a female. They were
And-
female. They couldn't do
and no
DNA, but they could
explanation.
only do mitochondrial DNA. They could tell the genetic, what the genetics were in the sense of was it male or female in terms of whether there was a Y gene or not, and it was female. So there was no, it wasn't male hair, and it was in the palm of one of the girl's hands, which usually means you're like
some
that.
sort of struggle, something.
Right.
Yes. And Disney nerd, yes, she points out that one of the confessions came after he was dining on his own excrement, which either before or after doing that, I think is questionable timing. So
Yeah, hint, and then, but they did testify there was what leads to him. They say is this cartridge that's found near the bodies on the next.
it was
day,
actually an unspent
unspent shell,
bullet, the whole
right.
thing.
Right, the whole thing, the whole cartridge,
Yeah.
right? Unspent bullet and the whole cartridge, and it was found the next day. Now the question is, of course, was it found as part of the scene of the crime, or was it there before the scene of the crime? I mean,
Well, the other thing,
and it matched. Supposedly, it matched something in his house.
well, yeah, a gun. But the thing is, if it's not fired, okay, you don't get rifling
Markings.
marks. You don't
Right.
get markings from an unfired bullet. You
Right.
know, so
Right.
so what? I
So
think
what?
Hold on, I think I can find a bullet here. Hold on, let me see if I can find one for you. I think I used to have one hanging out here. Oh, there's one. This is an unfired bullet. This can't be linked to anything except now my DNA is all over it. But other than that, this doesn't mean anything.
Yeah, but if
And-
that bullet and that cartridge is found somewhere at the scene of the crime, I mean, there's millions of these.
When there
things.
was, but it wasn't a shooting crime.
Wasn't shot. They weren't shot. And also it leads you to two young women had their throat slashed. How do you hold them all? How do you hold them unless you have two people involved in the throat slash, or you tie one up, or the mechanics of how you do that is unbelievable. It just
I can't imagine one of the 13 or 14-year-olds is going to stand by and do nothing.
Right.
Whether it's being tied up before being killed, it just makes no sense.
Makes no
This could be
sense.
done by one person.
Yeah. So we still don't have Bob. All right. So we may have to bring him
I
back
guess
on.
Bob will owe us a visit, I guess.
Bob is going to owe us a visit, but I can see our chatters are into this case. Disney Nerds said apparently it's the same type of cartridge. Oh, he's coming in now. Wait,
he's coming.
okay. Now.
So let's
Okay,
just
we
do
have
some of
inside
this.
information. Oh, there it is. Inside information is now published, so we can't go to jail for inside.
What happened?
information.
What happened?
Disney published. He's coming now.
Oh, okay. Well,
I said-
we've now set expectations very high.
Yeah. So I just want to see what his reaction is, and the fact that Defense Diaries really gives you, because Bob is a lawyer, his wife is a lawyer, what's really happening in that courtroom. I saw some reports today that was like, whew, and people then interpreting some reports were like double, phew, okay.
Yeah.
But he's telling you exactly what's happening in that courtroom. And the only problem you have is that you have that jury from that area who wants to give justice to these two young women. But we all know that when you start doing that, and you want to please your neighbors and you want to please other people, and you don't listening to the evidence and whether the evidence proves guilty on a reasonable doubt, and we don't know if it's going to do that yet.
Yeah. The sympathies are huge. We get that. Yeah.
Yeah.
But that doesn't mean you just convict whoever's sitting at the table.
Which is why I told you earlier today, the Sarah Boon trial, the family had to sit through the medical examiner there. In this case, the family had to sit through. There is Bob Motta. I think I see him.
Oh, there he is. He's on the road.
There he is.
There he is.
There he is. We
What's
were
up,
kind of.
y'all? Sorry I'm late.
Just in
okay.
time.
Just in time. We were about to say goodbye and say follow Bob Motta, and we were talking about the fact that you got a confessions to shooting, you've got an unspent cartridge, and you got two girls who were brutally shown to the.
I found this, Bob. So I'll be on the witness list.
So give us the
that's-
facts, Bob.
Just happened to have one.
Long day, brutal
Long
day
day.
in there. Today was basically proof of death witnesses. So we had the CSIs on there, 3 of them. The day ended late. It was like a 5:50 end. With the last CSI still on the stand, he was the one who really took a bulk of the crime scene / victim pictures, which were brutal. And if there was any question going into this trial whether or not they were going to be displaying those photographs to the whole courtroom, they did. They have a big 85-inch touchscreen, so we all saw it, and it's brutal. I mean, it's like a lot of the crime scene photographs are taken from a distance, so it's not quite as shocking. But you get to the ones where they're closer up, and it's hard, and it's hard to sit in there, just in general. But you've got the family sitting right next to you, and it's a tough experience anytime you're going through that. Like I always feel that this, like, proof of death is the toughest part of the trial before we start getting into the arguments about shell casings, unspent casings, and the science side of it, and the that part of it isn't nearly as you kind of push that aside and kind of move it back out of your mind a little bit so you can survive it. But yeah, this part of the trial is always very difficult, just in general, when you're talking about, especially when you got two beautiful young girls who lost their lives. So, but yeah, it was a long day. We had no morning break. She went right into a long lunch, hour and a half, and it was all really foundational stuff to get a ton of photographs in. So crime scene in general, a lot of the photographs of the girls, and in the state that they were found in. So it was a long one.
Involved the family? Were the families in there for this?
Yeah, they were.
Oh boy, that's brutal.
Yeah.
That's just
It's
brutal.
See, they went on Saturday too, right? You guys went on Saturday, which I'm okay with because the jury's sequestered. So that's
exactly. I mean, that's the rationale behind it. Like, and when we say sequestered, we're talking like draconian, like no phone, no computer, very limited TV that you can watch. That's it. No contact with anybody. They get a family day on Sunday that is under the supervision of the bailiffs. So it's like she's taking it really, really seriously in terms of keeping these people just completely shut out from the outside world. So, and I respect it, but to your point, Michael, yeah, it makes sense as to why, she's doing the Saturday half days, because those are brutal circumstances for the jury. So she wants to try to get this thing done as soon as possible.
Now, Bob, the I know you've been posting under Indiana law, these exhibits, once they're marked, are public documents. Now she's allowing the press to see the exhibits that may not be the ones that's displayed on the screen for 15 minutes a day. That's all the media that wants to come in, or the media and the public, or what?
Well, it's supposed to be public. My wife, Allison, tried to get in there. She was in there on Saturday covering it because I was in the Berkshires. And she went up there because there's an act, the Public Records Act. And as soon as it's entered into evidence, it's a public record. So she went up, and a reporter's like, "Oh, do you have your credentials?" And they had words. And then the reporter says, "Well, we'll ask Judge Gull, who happened to still be on the bench." She addressed Allison. She says, "Ma'am, do you have credentials?" Allison says, "No, I'm the public." And so just as ma'am leave the the courtroom, Allison went to go cite the statute. The judge said, "Ma'am, leave the of the courtroom." She's like, "Okay, Your Honor, but just so you know," and just, "Ma'am, leave the." And she got progressively louder. So Allison's like, "I'm not going to push it." So she ended up leaving. So yeah, it's we're today though. I think everything that was introduced was there wasn't anything that we didn't see today. Everything was put up on the big screen. So in terms of that, I don't think there's any kind of issue. We kind of broke right when we were moving from photographs to when they were gonna move the physical evidence in. So that's where we're gonna pick it up tomorrow. Same CSI on, still under direct, and we will be moving all of the actual physical evidence in. So that'll be probably the better part of the morning, and then we'll go into cross examinations. Were interesting. There was definitely an attack on certain aspects of the investigation or lack thereof. I find it incredulous that they did not take any of the sticks that were placed on the bodies for a month. Well,
Excuse me? Excuse me? For
Where
a
were
month?
they?
Where were they?
I misspoke. I want to say, so the 17th, they went back and picked up the sticks, claiming that they think that they knew which sticks they were on March 3rd. So couple,
Wait. Weeks?
Yeah, you heard it right. You heard it
Okay.
right. Yeah, he's saying, yeah, we didn't think there was any evidentiary value. And then like Baldwin's like, well, what about the ones with blood on it? Blood on sticks?
Right.
That's evidentiary value, right? And the cop finally said, yeah, it's unbelievable. I mean, if you like Baldwin was like, oh, well, don't like a human being had to touch that stick in order to put it on the girls, all of them, right? So potentially he left DNA. The guy's like, well, unless he was wearing gloves. And then Baldwin asked him, he said, well, was the perpetrator wearing gloves? And the investigator said, I have no idea. He's like, exactly. That's why you take the sticks and you test.
Oh, man.
So like that, and I'm trying to look over to the jury, see if they're taking notes.
Right.
There were a couple things like that were a little bit stunning, the kind of the chain of custody with respect to unspent round that came up. And it was pretty interesting, because we have a situation. So the whole mystery of when the round was discovered has been solved. They found it. They were using ASL alternate or ALS alternate light source. And one of the CSI that did not have the goggles on kept seeing a glimmer, and he's like run it over that again. And so they see kind of the casing itself with the primer like in the back. So there's no other photographs. It goes from being in the ground, partially covered, to the next time it's photographed, I think is at some point in a lab, I think. But the point being, from the perspective of the defense, is like, well, why didn't you like hold it up? Because the projectile, the bullet portion of it can vary. It's like, we want the jury to know that they're looking at the same bullet here that is the bullet that was found at the scene and in its natural state. So like, it could be many different materials. The projectile portion of the cartridge could be made out of anything. There's several things that they make it out of. And, they didn't really have an answer for it, and they kept trying
How
to
about
pin
Bob?
down.
How about Bob? The timing of it being there. I mean, was it under the bodies? Was it over the? I mean,
It was
just the timing of how it could have gotten there.
well.
Too. It doesn't have to be at the time of the crime.
They didn't address how it could have gotten there. They I mean, in terms of when they discovered it because there had been all kinds of rumors out there that it was discovered weeks later. It was discovered on the 14th of February, before the girls' bodies were even removed from the scene. So they found it pretty early. It wasn't buried in the dirt. It was just kind of under some leaves. How it got there, when it got there. I mean, look, I went and walked that area, the whole trail system the other day. I didn't want to trespass, so I didn't go down to the crime scene itself, but I walked the cemetery, and you can kind of it's on a ridge, so you can look down and see approximately where it is. And, I mean, it's just that whole trail system, and is an area where a lot of people are constantly walking around, even on the private property. You know what I mean? It's just like kids are in there all the time. It's a beautiful trail system. It's eerie to be in there now, but it's especially in fall, it's beautiful. It's a really nice trail system. All right, I gotta run. My wife keeps walking in front of the car. I'm sorry,
Bob. Thank you.
Nope.
Thank you very much.
And
Appreciate
when
it.
are you going to be on?
guys.
When are you going to be on so people can tune in and get the full story from you?
Yeah, I'll probably be going on 8:45 tonight.
Okay.
Live Eastern.
All right.
Eastern time?
Yeah.
Okay. Thanks,
All
Buzz.
right, now
Thank
I'll
you,
keep
Buzz.
checking back in with you guys, but just like I was telling Michael, just kind of be forewarned. Sometimes we'll go 5:30, 6 o'clock.
Yeah,
So
we're flexible.
Yeah.
That works out.
cool.
We're good. Hey, well,
Take
you're
care,
our
bud.
front. Bye.
All right. Well, good. I'm glad we worked that out perfectly. Timed that
And
out.
so he'll be back to talk about it on his show, 8:45.
Yep. So,
I think somebody named somebody we know is going to have a busy night.
Who would that be?
I don't know, some producer. We
Oh
know.
yeah, man, probably a long night. Yeah.
Long night.
All right then. So you got any other scraps? Any other odds and ends before we bag it?
I think that's it. Do you have any questions for us before we bag it? Anyone out there watching? Let us know right now.
Anybody have any directions for me for tomorrow? Anything you want to know about, think about, see, hear? Anything in particular? Just send us a little note.
And if something crazy happens, we'll try to jump on tomorrow night after court.
Yeah, we'll definitely. I don't have any real hard and fast plan, but certainly if she testifies,
Right.
we
may jump on tomorrow after.
We will.
I'll be back
after court.
Yeah, I'll be back after 4:30. So if you have to jump on without me, Michael, you'll jump on without me. And then
I don't
Wednesday,
think we'll get out of court that early. So it should be after 5.
And then Wednesday, we're trying to do our normal Q&A at 1:00 in between while there's a lunch.
Yep, I'm going to find a spot to park during the lunch break.
And we have, and Wednesday we have our guest questioners coming on.
That's right. That's right. So
that's right, and you know who you are. Okay.
Yep.
Okay. She's due to testify, by the way, between 10 to 10:30 tomorrow. So you'll be right there for cross-examination.
Okay. Well, yeah. Well, who knows how long that narrative is going to take, right?
That could be a long time. All right. Thank you all for joining us.